As to what criterion can be applied to determine when a condition of threatened security arises, we can perhaps only speculate or turn to the thinking of eminent minds. Shimada's high rank and position was not bought at the price of membership in the Nazi Party of Germany. As a member of the Navy, he belonged to a powerful organization which the evidence has shown never caused the fall of a cabinet or prevented its formation, and seldom took the initiative in state decisions. The culmination of events that led to war on December 1941 reminds us of the rule of law regarding proximate cause. The causes that are merely incidental or instruments of a superior controlling agency are not the proximate causes and the responsible ones, though they be nearer in time to the result. It is only when the causes are independent of each other that the nearest is, of course, to be charged with the disaster. It is with a sincere and honest appraisal of the evidence presented in this case that we ask for the acquittal of the accused Admiral Shimada Shigetaro on all relevant counts in the indictment.
Mr. McManus. Mr. President. Mr. Nevin.
Mr. President, members of the tribunal, I might say before I begin that I was in the midst of preparing an errata sheet in connection with this summation, anticipating that the Iraqi case would not be presented before, would not be concluded before tomorrow afternoon. However, I request too, Mr. President, that any portions of the summation which I do not read and which I do not ask that be deleted be made part of the transcript of the record. There will be quite a number of pages which I shall not read. As to whether the gradual extension of the China incident was absolute. Conclusion. A, first period. We submit that the evidence establishes that during the first period referred to by the prosecution of Kaya's connection with the government, that is, until he became Minister of Finance in 1937, he indicated his peaceful attitude, intentions in opposition to the military from the early 20s when, at the London and Geneva Naval Conferences, as a government official in a minor capacity, he exerted every effort to obtain the agreement for the reduction and limitation of naval armaments, that he was not and did not participate in a conspiracy or participate in planning or initiating an aggressive war, and that he is not guilty of the charges contained in any of the counts of the indictment covering that period. Second period. That during his brief tenure as finance minister in the first Hanoi cabinet, he was opposed to the extension of the China incident. That he was finance minister such a short period of time before the incident occurred that it would have been impossible for him to have known that the incident was contemplated or planned. That he had no part in it and had nothing to do with, and that he had nothing to further the Manchurian incident, and that he did nothing to further the Manchurian incident. And his opposition thereto and well-known attitude for peace is indicated by the fact that he was requested to resign. The prosecution does not contend that there is any evidence in the record to sustain the counts of the indictment in groups 2 and 3 against Kaya. We submit that the entire case of the prosecution against Kaya is of the same tenuous character as that indicated in his presentation with reference to groups 2 and 3, that there should be a finding of not guilty as to him on all of the accounts in the indictment. With which he is charged. The prosecutor has made reference, where's that next page? Where is it? Where is that next last thing? The prosecutor has made reference to almost every event that occurred from 1931 to 1945, date of surrender, not even excluding the period from 1917 and thereafter, when he first entered the finance ministry as a clerk by competitive civil service examination. I now conclude our summation with absolute sincerity in the integrity of our defense. The first 4 acts already passed. The fifth will see the closing of the dream of the day. Time's noblest offspring is its last.
Mr. McManus.
Mr. President, members of the tribunal, with your permission, I shall resume with Iraqi's summation, starting at page 248. Conclusion. If Your Honors, please. I'm sure that every one of you members of this tribunal understand that my sole purpose in coming to Japan was certainly not to free an arch criminal. Frankly speaking, if that was so, I can assure every one of you that I would not be here. And I hope and I know that you all believe me. My purpose in defending General Iraqi is to present the facts. Not only to present the facts, but to do it in a fair and square manner, which I think and I hope that I have done. Your Honors have said on many occasions that you are not jurors but judges. Nevertheless, as I dared to point out to this tribunal on one occasion, Your Honors are acting in a dual capacity of judges and jurors. I still know and am of that opinion, and that Your Honors and Your Honors alone are the men to decide the fate of these accused. Now, for the moment, considering Your Honors as jurors, my job is finished. The responsibility that I had during the course of this trial now shifts from me to you. I know from my experience here during the past 2 years that this court will do everything in its power to be eminently fair. I only ask you to consider the evidence very carefully, which, of course, I know you all will do. And further, in view of my personal experience in this tribunal, I know that wherever there is the slightest doubt as to the guilt of the accused Iraqi, you will give him the benefit of that doubt. It is my contention that Iraqi is innocent. I hope and pray that Your Honors will come to the same conclusion. I humbly ask Your Honors to return this man who, in the waning years of his life, has spent these past several years in prison, to the society to which he rightfully belongs, and I sincerely beg Your Honors to acquit him.
Appendices. Mr. McManus, what do you propose we do?
I beg your pardon, Your Honor?
You have a number of appendices here.
Oh. If Your Honor pleases, I laid the foundation for Your Honors to please read those documents. I do not intend to read them. They are rejected documents. There are about 5 rejected documents of 4, and I laid the foundation as to it's Your Honor's choice whether or not you care to read them or not.
Appear in the transcript. I'm going to tell him that. That's why I asked him.
が含まれております。
Mr. Cordell.
Mr. President, with the permission of the tribunal, I will proceed in presenting
The summation of the accused Shiratori.
ただいまより被告白鳥の個人最終弁論を提出いたします。
Division 1, General. The defendant Shiratori is indicted on counts 1 to 17, 27 to 32, 34, and 44. That is to say, he is indicted only on counts common to all the accused in the present case. It may therefore be said that the gravamen of a charge against him is his alleged involvement in a conspiracy or conspiracies which the prosecution contends existed during the period from January 1, 1928 to September 2, 1945.